it's emerging. One that's not listed here is an emerging category of self-audit, which is the self-certification process. So we have a lot of clients now that are getting letters from publishers that say, we'd like we have a contractual right to verify your compliance, and then accordingly, we're asking you to conduct a review of your licenses and either certify that you didn't need to buy anything or that you bought what you needed to come into compliance for both present compliance as well as historical usage that may have been unlicensed. And I see a big trend in this area. In this self-audit category, which has historically been the purview of the trade groups, the Business Software Alliance, also known as BSA, the Software Alliance is their new name, as well as the SIIA. For those of you who don't know much about these trade groups, in the early 90s, the SIIA began sending letters to businesses requesting that they participate in a self-audit process, and a form of those letters continues to be in use today by the SIIA and has been adopted for many years and being used by the BSA. The primary difference between these trade groups is that Microsoft is a member of the Business Software Alliance, and therefore almost all Business Software Alliance cases have at issue Microsoft's products, but they also are very heavily focused on Autodesk and other Adobe and other members, where the SIIA also represents, in some cases, Adobe and Autodesk, but never Microsoft. And sometimes we see clients where they've got both of these agencies after them at the same time. But if you are a large enterprise or mid-market company with greater than, say, 200 devices, of which there are many on this call, the probability that you're going to be wrapped up in an agency-type audit is fairly remote. What I've seen in the large enterprise is maybe divisions of the company or smaller units, smaller business units, perhaps in other countries. We've seen BSA cases in India and South America, and sometimes we'll see a large enterprise client getting hit with agency requests in other countries. BSA operates in over 55 countries and is quite active on a global basis. So I would say this list of software audits is fairly comprehensive, and there are different flavors within each. So for example, a third-party audit conducted by KPMG for Microsoft is really going to have a lot of differences from a third-party audit conducted by Deloitte related to IBM licensing. And so, but these are good categories to think about and to understand. And we'll talk about how we adapt our audit process from a defense perspective to the various flavors as we get into them further. So I would say the biggest category of audits in the marketplace is the publisher initiated. So when I talk in terms of publisher initiated, I think the best example of this would be Oracle's LMS. Oracle has a license management services group that initiates audits, conducts audits, and there's no third parties involved. You're dealing with Oracle on an Oracle audit, and there's no independence involved, and there's no third parties involved. That is what I refer to as a publisher audit. And again, the key in defending publisher audits and understanding them is that they really are a creature of contract. In other words, the publisher has the rights to audit that arise in the context of the contract's audit provision, and frequently publishers will take liberties with the breadth and scope of what they're asking for in connection with an audit versus what the contract actually provides. Most audit provisions will say things like, as long as it doesn't unreasonably interfere with, and so forth. And so there's some room, even where there is a contract that gives a right to audit, there frequently is some significant negotiation that goes on regarding the scope and processes around that audit. In the independent audits, you have scoping calls with the auditors where you talk through and negotiate. You know, you're talking to KPMG and they've got a scoping call and they want to know, what tools are available to gather data, and you talk through it with them. With the publisher audit, there is no no built-in mechanism for scoping similar to that, and so you wind up having to push back on their requests in some instances to move to a more reasonable ground, and disputes can arise over the scope and breadth of an audit, and there's even been some recent litigation over when a publisher has the right to audit, the extent to which the customer has to do the heavy lifting. And so that's an interesting question as to what is it to meaningfully cooperate if you're a licensee, and does it require things like running third-party tools and so forth. And so these are the types of issues that you get into when you're talking about publisher audits. Again, you see the word here, independently. Independence is a term of art in the accounting world. It has to do with their type of engagement. An independence engagement is an engagement where there are certain ethical rules that will bind the auditor to not being so is not an advocate's role, but merely attempting to make calculations in connection with the engagement. I would tell you that in my experience, I find that third-party auditors generally resolve all inferences in favor of the publishers. Their assumptions and extrapolation methodologies frequently are very one-sided in favor of the publisher. And so when we're involved in audit cases involving third parties such as KPMG or Deloitte or others, we work very carefully to validate their work product and to document any objections that we have to their methodology or findings. One of the things that comes up a lot, particularly in the Microsoft context, is the SAM engagement. Is it optional? Is it not optional? If it is optional, should you opt out of it? I generally advise my clients to decline any type of optional SAM engagement or any kind of review unless there's some strategic, business reason to do it that's not readily apparent. I look at SAM cases or SAM engagements as just an audit by another name. And while there may be differences in terms of how things get resolved, as a general proposition, I've had more clients that have had problems with SAM engagements than those who have been disappointed by the fact that they declined them. And so if your organization is prone to just share information just because someone comes along and asks, that's an area where I think some improved business processes could help mitigate the risk associated with software license compliance. This last point I think is very important, is that defending and dealing with software licensing and audits is a very time-consuming process. For my larger clients that are global, that are managing broad, diverse infrastructure, it's extremely difficult to gather all of the information that's necessary to accurately count the licenses under these very complex and frequently ambiguous licensing rules. And so anytime you can make it easier to count and figuring out how you want to license things in a way that's easy to count and account, you can certainly get some of that money back in avoiding very disruptive and invasive audit cases. So we talked a little bit about agency audits. They differ from the publisher audit and the independent audit in the sense that these are trade groups that operate under a power of attorney from the publishers that comprise their membership. And so the publishers sign an agreement that says, for example, with the BSA, I'm giving you power of attorney for enforcement of my intellectual property rights, including my copyrights. And then the BSA goes out and markets through Facebook, radio, print, number of other strategies, offering trips and reward money to disgruntled employees and former employees, and essentially are looking for people to make anonymous tips about any software license compliance issues that they may have seen within an organization where they currently work or may have worked in the past. And then letters are sent out, most frequently from outside law firms, and they have a network of law firms that they use to send these letters out. But essentially, the message is put a stop to piracy, turn your boss in, and recover reward money that you might use to pay for the holidays or to go on a vacation or the like. And for those of you who don't know, I actually got started in software law because the BSA audited a company that I was the CEO of back in '04. And that is how I got my start in handling software audit cases, and have handled at this point over 300 BSA audit cases since that time. And again, BSA is really a generally targeted at the SMB market. You see some names here that you might recognize with some funds, and you could see that this is a fairly old slide. I'm dating myself a little bit with this old slide. But the point is that many of the settlements are in the range between, we see them as low as 10 to 20,000, and sometimes in the $500,000 range would be sort of a very high case. I settled one recently for 600,000, and it was one of the larger settlements that my client had made in a BSA case. And so to make the point here is that this is an issue for SMB market clients, typically 50 to 150 devices, companies that are too small to have a very robust IT operation in terms of in-house resources, but still big enough for where the fines can add up to some significant dough. Similarly, the SIIA runs a tipster-based, lead-based approach. And the point here is that the SIIA, in some respects, is in competition with the BSA due to the overlap in members. So in some instances, you could have somebody that would make a report to both agencies, and a client could wind up with two audits, and difficult to sort out, who's going to handle what. But sometimes what will happen is both will go forward, but the first announced audit will be responsible for the publishers which are in common. And if the SIA has, for example, if the SIA was the later filed, later served audit, then only those unique to the SIA would proceed. So now we've covered sort of some of the typical types of audits, and now I want to talk about legal issues in software audits, and why lawyers are increasingly part of the resolution and the defense of software audit cases. In many instances, and for many years, issues regarding license compliance were handled primarily as an IT issue with limited support from either inside or outside law firms. But over the years, the relationship with the publishers has, I think, deteriorated. The sense of partnership and working together between licensees and licensors, it seems like things people say in the sales process, but in reality, my perspective is over the years that I've been working on these types of cases is the incidence of disputes, the frequency of audits and verifications, the complete lack of trust is evident in many license arrangements. And as a result, it requires a lot more legal work, both at the time of drafting the agreements as well as in the event that a dispute arises. And, the interesting thing about software cases is you have an interplay between state contract law and federal copyright law. And so in each case, you're looking at sort of both aspects of the law, but you start with the contract, and the contract is, what is the license? Who is the license for? What is the license grant? What is the scope of the grant? And what are the appropriate licensing metrics? And to what extent are we able to confirm that we're in compliance with those terms? And frequently what I find is that the contracts are ambiguous. It's been a long time since I've seen a software license agreement where I couldn't find at least one ambiguity. And therefore, extrinsic evidence becomes important. Things like, what were the nature of the negotiations before the agreement was entered into, and anything else that would shed light on the intent of the parties at the time of contracting. Frequently, we get into disputes about how to count. What is an account? What is a user? What does it mean to use? These are the types of questions that frequently arise, and the user-based, what is a user is always, for example, evolving. And I think one of the trends that we're going to see next year is a lot of fighting over software licenses that involve users. As we move to more user-based models, such as cloud, I think that over time, what we're going to be looking at is a lot more disputes from a contract perspective over what does use mean and who is a user, and looking at these indirect access scenarios where the publisher is going to take the position that a broader universe of users are required to be licensed, while the licensees are saying no, these users don't really have any derive any benefit from the application, even though they may be part of a more complex computing infrastructure. And I see that as a big trend. But the point here is that there's always something ambiguous or unclear about a license agreement, and then the question arises, how do you resolve those in light of, and what is the interplay with copyright law? Because all of the litigation that I've handled involving software licenses, there always is a breach of contract component, and there's always a copyright infringement component. And the reason that the copyright infringement case is there is because the availability of damages is much greater. The preemption of state law and the copyright infringement shifting of the burden. So, for example, in a copyright case, if I'm the licensor and I prove that you use my software and I prove that I have a copyright, then the burden shifts to you to establish a license. And if you have the burden of showing a license, suddenly all those ambiguities in the contract are no longer your friend like they were under contract law, because you have the burden as the licensee under copyright law to show a license. And so it's interesting to see, the interplay. With copyright law, copying is prohibited. And so in software cases, we'll frequently be looking at, was there unauthorized copying took place, and what constitutes copying? And there's some interesting case law in that area. But in the absence of copying by the licensee, copyright case is very tenuous to make out. The other thing that's the benefit of copyright law is that you have much greater liability, the ability to pin individual liability on those involved in a software licensing dispute is much greater under copyright law. So under copyright law, anyone who had the ability to control or benefit from the use of the software is potentially individually liable under copyright law, whereas under contract law, you'd have to draw a link. The other issue that comes up quite frequently in audit cases is some sort of intervening M&A activity, where either during or before or for some portion of the auditing period, there was M&A that complicates the factual basis of what's being looked at. But the important thing to understand here is that if you're in an organization that's engaged in any significant M&A, my experience is that many companies are doing a poor job of IT diligence in terms of they'll get into, for example, they'll close a deal to buy a company. They won't do any real due diligence on the company's licensing situation. And they'll, on day one, when they close and they take ownership of the IT assets, now they're responsible for any infringing use as of the date of the closing. And so it's important to sequence IT due diligence as part of your M&A activity. Another example that I see a lot is my clients will enter into a sale of a business, and they'll enter into a transition services agreement with the buyer to continue to allow them to access their IT. But in many instances, when you inquire into the software licensing schemes, for example, what you see is that the ability to allow third-party access under that transition services model is prohibited by the licensing terms. And so again, this is an area where better diligence will avoid liability in connection with M&A activity. So what are the common mistakes that we see? I would say this response that says they have an audit provision, so I've just got to negotiate with whatever they ask me. I've had so many cases where the process was not managed correctly at the outset that led to a significant dispute that could have been avoided. And that's been a pattern that I've seen repeated many, many times in a variety of different contexts with across the spectrum of publishers. If you are the target of a software audit, you need to very carefully understand what your obligations are, but at the same time, you need to have a proactive agenda about how is this audit going to go down. It doesn't have to go down exactly the way they say they want it to go down. Very rarely does a publisher's audit clause get to the level of specificity of detailing things that are subject to negotiation in connection with a pre-audit agreement. And I would say that negotiating the procedures, the scope, the tools that are going to be deployed, all of that, what all the documentation is going to be, all that is critical to avoiding bad outcomes. The other thing that we see is sometimes people don't understand the timing aspects of a licensing review. So in some audits, you're taking a snapshot in time, and whatever was installed on that date and whatever entitlements you had on that date, that's the effective date. Okay, an example of that would be a BSA audit, an SIA audit. Those are snapshot in time type audits, and those you really need to work hard to make sure that you're not including machines that were deployed after the effective date. You're not including invoices for purchases that were made after the effective date. But in other situations, they may be, auditing your use of the software during the term of the agreement. And so failure to understand and appreciate and look at data for some other period other than the initial snapshot could create a problem where, for example, the publisher is looking for look back or back maintenance or something like that, which frequently they will be looking for. And so really understanding what is the effective time for the audit is critically important. And the other thing that causes some trouble is avoiding this natural instinct to say, I got audited, I did an internal investigation, and I ran out and bought the software that I needed to come into compliance in response to an audit letter. I generally think that's a mistake. There's a time and a place to deal with gaps in compliance that are revealed in connection with an audit, and the audit notice, in my experience, is not the best time to make a knee-jerk purchase. The other thing that I've learned over the years is that there's a significant organizational impact around audits, particularly large audits that result in significant disputes. And one of the things that I get asked all the time on calls with prospective new clients is, how long is this going to take? And I think that a lot of times clients that haven't gone through software audits or don't have a lot of experience with them are surprised to learn how long they can take. And while there are some that can be resolved in weeks or months, there are many big audits that go on for 18 months or even beyond. And so there's an impact to the organization, and the siloed approach to defending audits, in my opinion, always leads to poor outcomes. But when you've got the right senior management, and I refer to that as the person who can write the last email in the string, that executive sponsor that's going to make the highest level business decisions and ensure that appropriate resources are allocated. When you have that person involved and supported by both legal, IT, finance, and procurement, then you've got the right voices in the room. Many of my large clients actually develop audit defense committees. And when they're global company dealing with thousands of vendors, you've got a handful of audits going on all the time, people requesting, and you want to manage them. And so they've developed multidisciplinary audit defense teams to vet, to review, to collaborate, to ensure alignment. And when you focus your team building around the issues of license compliance and the IP risk associated with a team like this, what we find is that clients get the best outcomes. Whereas, for example, if you just had legal here, if you just had IT or just procurement handling it, I think your outcomes would be worse than having a multidisciplinary team involved. So some of the financial impacts of software audits, some of these are pretty well known or easy to think about, but I think the part that some people don't appreciate is the difficulty of doing the discovery and the proof of purchase analysis. A lot of time is spent, particularly by large organizations, just ensuring that the software discovery is complete and accurate. We work with our clients to help them with triangulation strategies around comparing their software discovery to other data sources within the organization, for example, with antivirus software deployments or Active Directory objects. And you'd be shocked at how time-consuming and challenging this software discovery phase can be for a large organization. Similarly, for organizations that have distributed footprint and non-centralized purchasing, the ability to compile all of the license agreements and other proofs of purchase to show entitlement information can be a significant challenge as well. The gap analysis piece is really what our lawyers have developed the expertise in, is the ability to take discovery data and licensing documentation and purchase history and build an effective license position calculation that would be defensible in an audit or in a court case. But again, audits are very expensive. They touch a lot of groups within the organization. If you're using an outside firm, you can have the added expense of that as well. And so the best audit, in my opinion, is no audit. And so frequently when I'm negotiating for large clients that have a lot of negotiating leverage, which gratefully many of my clients do, I ask for audit forbearance. It's a standard request that I make when I'm doing licensing transactions for my clients, because I know how difficult it is to deal with all this stuff and how expensive it is for my clients. And the best time for my clients to demand a forbearance or no audit type provisions is when they're doing new deals and engaging in procurement activities where there's a big check and an audience with the publisher to hear your demands. So, as I said, audits are time consuming, they're expensive, and they are annoying in many ways. And so if you can avoid them, you should. Over the years, we've developed a process for audit defense designed to help clients deal with some of the innate challenges associated with audits. And you could see here from this slide that the starting place is data collection. What are the data sources that we're going to be looking at to measure your deployments, and how are we going to make sure that we can defend those from a completeness and accuracy testing perspective? How can we prove, how will we prove that the data that we say represents what's discovered in your environment is what is actually there? And there are a number of tools in the marketplace, and many of our clients, frankly, have too many tools. So what we have found is that in our large enterprise clients, that there'll be a variety of discovery tools in play, but no one single source of discovery data that gives you the entire picture. And it's quite a challenge for a large organization to fully deploy any discovery capability at 100%, penetration. Very difficult thing to do. But without it, you really don't have the factual basis to determine, what you have deployed. And deployment data is always the factual issue in a software case. Users, software installations, these are the issues that are going to drive the claims of lack of compliance. So the next step that we look at is, what are your entitlements? So entitlements can come in a variety of ways: a software license agreement and associated purchases, invoices, for example, that show the operating system that came with hardware, invoices from software vendors showing license purchases. All of these documents could be entitlements, but what I have found is my clients are sometimes confused about what constitutes good proof and what documents to hold on to and for how long. And so frequently we find that it is very difficult for licensees to prove with the documents that either the trade groups or the vendors want them to have, to prove that they bought the software that's running within their organization. I always tell people, it's not what you bought a license for, it's what we can prove that you have a license for. and sometimes those two things can be different. So the reconciliation and gap analysis, this is really where you take the deployment data, you marry it to the entitlement data, and then you apply the overlay of the applicable licensing rules. That tells you what your gap is. You can't know the gap just by doing math, because the gap is dictated by licensing rules. A good example of this would be upgrades and downgrades. If you've got some extras of one that could be downgraded to another, straight math wouldn't give you your gap analysis. You'd need to first apply the licensing rules regarding upgrades and downgrades before you could arrive at a gap. So after the internal investigation is completed, usually there's some information sharing either with the auditor or the publisher or the trade group, and that would be the produced results. I generally will make sure that the auditors or the trade group or the vendor is under an appropriate, what I call Rule 408 agreement. That would be an agreement that specifies the circumstances under which they can use or disclose the materials that are being produced. And the essence of it is that we're producing these materials to you in furtherance of settlement discussions, and that they should not be used against us as evidence if a case is pursued. Then after the audit materials are produced or the findings are made, there typically is a negotiation phase where we argue back and forth over licensing interpretation, sometimes make requests for business concessions, and then we move into a settlement. And in the settlement phase of the defense process, sometimes you're also looking at bundling a transaction. So when you think about settlement, in many instances, particularly in the enterprise space, the settlement is memorialized into a new deal. And so you're not just looking at a settlement, but you're also looking at a transaction. And the one thing that I think is important, for lawyers that are doing audit disputes involving software, is to understand the importance of getting a release and requiring a release and being prepared to negotiate appropriate release language. Over the years, publishers have become leery of giving releases. And so it's typically a heavily negotiated issue, but can be very important, because if you think about it, there's going to be another audit down the road, right? And if you don't get a release coming out of each one, you're just building this potentially cumulative liability, and you're never really resolving anything. You're just kind of kicking the can down the road. And so, car accident lawyers certainly understand you don't settle a car accident case without a release, but sometimes in the context of software, some of that basic legal practice is sometimes lost. And so, if you don't take anything away from this webinar, get a release, get a release, get a release. If you're settling a dispute in an audit, one of the things that the legal team should be delivering is a release and a clean slate. So we talked about some of the challenges with discovery. Generally, we're looking for automated tools, and the tool selection is a big part of it. The right tool for one type of engagement is not the right tool for all. And I generally think that you're going to be best served by at least using the tools that the publishers or their auditors are going to use when they're measuring your compliance with your agreement. Because if you're using one data set and they're going to request a different data set to measure your compliance, then you're really not mitigating risk. And so the tool selection process and how you set up your discovery within your organization can be critical to success. And, the understanding that this is not a one-time thing. the need to discover what software is running on your computers is going to be a repetitive issue, and it's something that you're going to need to resolve, not just in response to a software audit, but more generally. And the frequency and incidence of audits, in my experience, is just increasing. It's not going down. And so to have any solid program that is designed to put your organization in a better position regarding software audits has to be rooted in a reliable, repeatable discovery process. And we generally recommend that you work both in terms of with software asset management, IT, as well as legal, to wherever possible ensure that the data is protected by the attorney work product privilege. In some instances where we're issuing reports, those would be protected by the attorney-client privilege, and those could be very important privileges in the context of a dispute that might ultimately wind up in court, because the type of work that we do is would be very important to the licensor in terms of making their case regarding any compliance issues that might wind up in court. We talked about proof of purchases a little bit and some of the challenges associated with it. I've talked on this slide a little bit about some of the things that don't constitute proof, and I think that could be helpful. For the larger companies, I think leveraging your vendors is the key. You know, we have clients that are looking to have their resellers handle the vast majority of the data collection burden related to the entitlement side of the licensing ledger. And I think that those clients that are successfully leveraging the top resellers in the marketplace, that are centralizing their purchasing through those resellers and demanding of those resellers the type of reporting that makes it easy to demonstrate your entitlements at any given time, are the ones that are having the easiest time of this part of it. But for smaller businesses, for licenses that are being purchased, on credit cards, the so-called maverick purchases, this entitlement gathering exercise can be quite tedious and very difficult. And in the enterprise space, you wind up with a hodgepodge of agreements dating back, 20 years with a vendor, with a variety of orders and amendments and new agreements, and maybe some M&A activity where the owners changed hands, and you wind up with a bit of document soup that you have to work through in order to understand your entitlements, and that becomes a challenge in the enterprise context. So gap analysis, as I said, is both understanding the use as it pertains to the license grants. And so it's not straight math. It's not one install, one license equals 0. In many instances, there are license adjustments that need to be made to the basic math. And these are some of the things that arise in the context of doing that gap analysis in a way that is different than just the ones and the twos. And I think this last piece is the one thing that our clients, I think, have come to rely on us the most, is that, at some point they want to get their arms around the dispute. They want to keep it from escalating into something more than it needs to. And at some point very early on, they're going to want me to tell them, what's the money? How much money are we talking about? What is the potential exposure here? How probable is it? And what are our defenses, and what can we do to make it lower? And so I think it's a mistake to leave off the financial component of a gap analysis. And sometimes it's a mistake. People make mistakes when they do it. For example, they'll use historical discounts as the price that they use for the gap. Well, the publisher may be thinking, I not only want MSRP, but I want a 25% penalty, and I want some look back as well. And so you're calculating it one way at an historical discount. They're looking at it from a completely different perspective. And so understanding, when I do a fine exposure analysis, my goal is to estimate for the client the most probable starting position that the vendor will take. That way you have some insight, not into a calculation, but the calculation that is most likely applicable to your dispute. So audit materials, audit findings, these are the reports that, ultimately will identify a gap upon which a financial claim will frequently be made. And generally, you're looking at a table that shows the deployments, the license adjustments, the entitlements, and any gaps that you may have, and having some supporting materials in terms of either raw data that would have comprised the discovery data, or the entitlement data that for which the licensee is alleging ownership or license. One of the things that I think is actually probably should have been on the mistake slide is this management approval before producing results. I can't tell you how many cases I've been involved with where the general counsel that I'm dealing with, or someone high up in IT that I'm dealing with, says, "Rob, this just came to me, but there's the history here. This was going through, the organization long before I got wind of it, and we sent them in a lot of information that was not relevant or overly broad, and now we've got this big dispute, and we're trying to unring the bell." And so it's very important that you get the right leadership around disclosure of deployment and entitlement information regarding software deployed within the organization to avoid that kind of problem. Unfortunately, the market has evolved to a point where the publishers are using as a strategy, at least my perspective of their strategy is, start with an outrageously high number. I mean, the goal is, my perception of what a lot of publishers will do is figure out a way to make the numbers add up to a dollar amount that would be a material amount for a publicly traded company that would get on the radar screen of people who are sufficiently high up, regardless of, in many ways, what an objective review of the license position may be. And so what we find is that, our clients are frequently shocked with the first report or the first demand, in that they find it to be completely unfounded, completely disconnected from the business value that they've received, and in many instances in bad faith. And so we wind up getting involved in negotiating and saying, look, okay, they've made this demand. We can say nuh-uh, or we can come with a strategy that identifies what our objections is to what their position is and focuses on what we are prepared to pay, if anything, and what conditions we want to put on it. So I get involved in a lot of disputes at this stage where, data has been exchanged, the parties disagree on what that data means. There's frequently an interpretive issue related to the contracts. The publisher's on one end of the spectrum, and the licensee is on a completely different end of the spectrum. They've reached an impasse with respect to their ability to negotiate a resolution, and they're on the verge of escalating toward potential litigation. And when I get into those situations, one of the first things that I want to focus on is, okay, aside from how ridiculous it all seems to you, where is there a path to come out of this? Because you could always go to court, you could always file a lawsuit, but in my experience, most disputes are not well suited to court. Most software disputes are better resolved informally than through court. Now, there are some exceptions, but as a general proposition, we're looking for a resolution. And so my role is to help, based on my experience, to come in and bridge through some of the noise, have the understanding of what the market is for where these deals are settling on a regular basis with these publishers, and trying to develop a path forward where my client gets the maximum value for what they pay. Because getting software as part of a settlement that you could use in the future is a much different settlement than paying for a past penalty for software that you had installed but never used. And so just a sheer dollar amount analysis doesn't always get you to the best value. The value in resolving the case is getting the most bang for the money that you do spend. Even if you wind up spending a little more, if you're getting the software that you need, or the changes to the agreement that you need, or getting some headroom for future growth, then those can be things that can be more valuable to you than just paying a penalty. Settlement agreements. This could be, settlement agreements or new licenses. To the extent that you're making certifications regarding accuracy, many publishers are moving towards, wanting to get written certifications or statements from management in connection with settlements. You want to be very careful about that. You want to be careful about what you're representing, about what you've shown them. That could be very important. Future inspections, we never have clients agree to future inspections. And also think in terms of the non-monetary aspects of settlement. Everyone wants to talk about, how much is the settlement, but there are non-monetary things that do have costs, and confidentiality is one of those. To the extent that you are dealing with a publisher or a trade group that discloses information about your business, then confidentiality provisions in the settlement agreements would preclude that. The other thing to think about is, don't ever sign a settlement agreement in a software case that's going to put the licensee out of compliance as of the date that they sign it. The goal of the settlement is twofold. One, to resolve the dispute that has arisen, and two, to ensure that the licensing terms and the counts and quantities being acquired place the organization in present compliance. The worst thing that you would want to do is settle a case and still have a compliance problem. So you've got that twofold strategy. With that, I'd like to thank everybody for joining today. If you have questions that you've added, we'll endeavor to answer those. If you'd like to reach out to me directly, you can do so at the email address that's listed on this slide, or call me directly at my desk at 214-999-2902. Thank you very much.